The judge and Binger, the ADA, got into it yesterday. And let me just set up this soundbite. So basically, Binger did two things that ticked off the judge and the defense counsel. Number one, he tried to bring into evidence Kyle Rittenhouse saying a couple of weeks prior to this incident, in watching some sort of property damage, I think he just watched it online, right? He wasn't even there. I wish I had my gun so I could shoot these guys. It's just like bullshit rhetoric, right? Fill me in on that, Rob. Fill that out.
Yes, it's a 17-year-old kid who's just, it's kind of body talk. And there was a prior incident back in August where Kyle Rittenhouse was in the area, in the vicinity. There was a CVS video where apparently he was outside of CVS, and there's somebody recording footage of him watching shoplifting happening and saying something to the effect, if I had my weapon, I would be able to stop this from occurring. And so what Thomas Binger wanted to do is bring that in as evidence and sort of show that Kyle was acting in conformity with that prior statement. And so the way he fleshed this whole thing out, it was very underhanded in my opinion, but he started to walk down a line of questioning with Kyle Rittenhouse about property and about property defending property, and says, you can't shoot Rosenbaum to protect property, right? You can't use deadly force in order to save CarSource, which is the property that we were talking about there. And so he gets Kyle to agree a number of times that, yes, I agree, you can't use self-defense to protect property. So then he says, well, then why did you say that in that earlier August 17th or 15th date to that person who was recording you outside the CVS? And that at that moment, there was an objection from the defense, and the judge had already known that this was an issue that was discussed during the pretrial proceedings, that this shouldn't have been considered to be a wide open door for the prosecution to just walk through. Judge wanted Binger to give him some acknowledgement that this might be coming so the judge could issue a ruling. And when Binger didn't do that, the judge really scolded him aggressively.
Right, because the judge in the pretrial motions had said, I don't think I'm going to let that in. And when that is said to you as a lawyer, that means if I try to get it in, I got to get the judge's approval before I go here. I can't just spring this in front of the jury because I've already been admonished by this judge. He doesn't think it's coming in. And that's what the judge got so mad about. That was one. And the second sin committed by Binger was he said as follows to Kyle Rittenhouse. He basically questioned his Fifth Amendment right not to testify. So Binger comes up and says to him, "This is the first time you've told your story since August 25, 2020, isn't it? And you've had the benefit of seeing countless videos of your action that night and hearing the testimony of 30-some witnesses who have testified in this case." And the defense attorney, Mark Richards, objected. That was sustained. And the judge was mad. Why?
Well, because that's sort of the rule number one, is you don't comment on a defendant's right to remain silent. I mean, it's in the Constitution. It's a pretty sacred right. And it's one of the first things that I've never been a prosecutor, but I would imagine they tell you when you're going to trial practice as a lawyer, don't cross those sacred constitutional boundaries. And Thomas Binger is not an inexperienced attorney. The DA's office over there in Kenosha is not very big. I think we did a count of all the different county attorneys there, something like 9 to 12 different attorneys. And so you could presume that if a case of national importance comes across their desk, they're going to give it to somebody who they consider to be highly litigious, somebody highly competent who's been doing it for a while. And so that presumably was Thomas Binger. And Thomas Binger gets out there and in front of the jury starts commenting on the right to remain silent and a defendant's constitutional protection in that regard, then starts to even thread the needle a little bit further by trying to get that other evidence admitted from the CVS video that took place earlier in August. And so the judge is just seeing a very experienced trial attorney looking like they might be intentionally trying to cause a mistrial or straddle that line in a way that is not permissible.
Yeah, so that was some speculation that the DA was trying to cause a mistrial, as normally a mistrial is the case gets dismissed in the middle of the trial without prejudice. So you get a second try. And I mean, normally it's the defense attorney who wants a mistrial because you get the advantage of seeing the prosecution's whole case and then you get another bite at the apple, right? You're better positioned in trial too. But right now, the defense doesn't want a mistrial because they're winning. If they want a mistrial, they want it with prejudice, which they did ask for at the end of yesterday's proceedings based on the things that you just mentioned. But just here is some of the judge, this is leading up to now the accusations that this judge is some sort of a racist. This well-respected judge, he's, I think, the most senior judge in the Kenosha Circuit Court. So he is calling Binger to task for those two errors that you just outlined. Here's some of that exchange.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
He's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property.
He didn't have the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do. Just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that.
I thought, this is my good faith explanation to you, and if you want to yell at me, you can. My good faith feeling this morning after watching that testimony was you had left the door open a little bit, now we had something new, and I was going to probe it.
I don't believe you. There better not be another incident. I'll take the motion under advisement. And you can respond. When you say that you were acting in good faith, I don't believe that, okay? Let's proceed. Everybody in good faith.
Not a good day for the prosecution. Not at all.
Not at all. And to be fair, I don't believe him either. I think that he was intentionally trying to kind of squeeze that one through. If you did listen to the pretrial proceedings in a little bit more depth, then you would have seen that they discussed a lot of this stuff. And the judge is a little bit different than some other jurisdictions. So, for example, if you say this judge, compare him to Judge Cahill that we saw in Chauvin, just a little bit of a different demeanor. He's a little bit more loose, sort of likes to hear stuff on the fly. We didn't have a lot of resolutions on the pretrial proceedings, a lot of these motions in limine. And so he did say, yes, at a later time when the evidence comes up, when the time is right, you need to flag this for me, Mr. Prosecutor, Mr. Defense Attorney, so that I can make a decision about where this line of questioning goes or where this evidence should whether it should be admissible or not. And from my watching of it, it felt like there was a pretty clear understanding that that was going to be how this was going to work. It's you ask for permission when you get there. You don't just get to decide, well, the judge didn't make a ruling on this, so I'm just going to try to skate this one through. And you might excuse a prosecutor for making a mistake if they're a first-year prosecutor or this is not a case of national importance. But this is Thomas Binger. This case has been in national news for almost 18 months now. And so it's something that I think the judge is exactly right to presume that maybe there's something else going on here. Not in evidence yet, but it does feel underhanded.